Imagine you spend, I don't know, 20 years building a business.
Right. A lifetime, really.
Yeah. You put in the late nights, you miss the kids' soccer games, you shake thousands of hands just to build a solid reputation. And then you finally hire a junior associate to help carry the load.
You're trying to grow.
Exactly. You teach them everything you know, you introduce them to your best clients, really bring them into the fold, and then a year later they quit. They move right across the street and boom, half your clients go with them.
Oh, man. It's the nightmare scenario for any professional practice. You've essentially trained your own assassin.
You really have. But okay, let's flip the script for a second. Let's say you're the young professional. You're hungry, you just signed a contract to get your foot in the door of your absolute dream job. But the contract says if you ever leave, you can never, and I mean literally never work in this town again.
Which is a terrifying prospect.
Right, so you quit 5 years later, and suddenly you're being told you can't earn a living using the only skills you actually have. You have to uproot your entire family or, I don't know, change careers entirely.
And that, right there, is the tension at the heart of today's deep dive. For everyone listening, we are looking at a legal battlefield where the right to protect an established business crashes headfirst into an employee's right to work and make a living.
It really feels like an impossible balance to strike.
It is tricky. Specifically, we're breaking down the enforceability of what the law calls covenants not to compete, especially between professionals.
Because on one hand, you have freedom of contract. I mean, you sign the paper, right?
Exactly. But on the other hand, you have the fundamental human right to provide for yourself. And the stakes here aren't just, monetary damages. We aren't just talking about writing a check.
We're talking about injunctions.
Yes. Court orders that physically and legally stop you from practicing your profession. So, for our analytical path today, we are going to break down the rule of reasonableness regarding time and geography. Then we'll preview this concept called severability, often called the blue pencil doctrine.
I love that name.
It's very visual, right? It's what courts do when a contract is only partially illegal. And finally, we will conclude with a diagnostic checklist, a practical tool for determining if a restrictive covenant actually survives judicial scrutiny.
That sounds perfect. But before we get the Ritter blue pen out, we need to start with the baseline. Because my instinct, and I think most people listening would agree, is that telling someone they legally cannot work sounds illegal. Isn't that just a restraint of trade?
Yes. By definition, it is a restraint of trade.
So what's the general rule regarding professionals binding themselves not to compete with a former employer?
The general rule today is that covenants not to compete are enforceable, but they come with a massive condition. They are enforceable only if they are reasonable.
Okay, reasonable. That's one of those classic lawyer words that can mean absolutely anything.
It really is. But the law does break down the elements of reasonableness into a testable framework. There are three main elements. First, it must be for sufficient consideration.
Meaning they get something in return?
Right, usually the job itself. Second, it must be within a reasonable territorial extent. And third, it must not be injurious to the public. There's a strong public policy limitation against sanctioning the loss of a man's livelihood or creating a local monopoly.
So you can't just ban someone from the entire planet because they worked at your coffee shop for a week.
Exactly. But to really see how courts wrestle with this, we need a test case.
And we have a great one. Let's analyze Karpinski v. Ingrasci. This is a New York Court of Appeals case from 1971.
It is the absolute perfect vehicle for this analysis because it tests all of those boundaries.
Right. So let's analyze Karpinski v. Ingrasci. First, what are the legally dispositive facts? Who are these people?
Okay, here's the situation. The plaintiff is Dr. Karpinski. He was an oral surgeon operating in Auburn, New York, up in Cayuga County. Now, this is important context. This isn't a bustling city with a dentist on every corner. It's a very rural area.
So everyone knows everyone.
Exactly. And over many years, Karpinski built a very specific, extensive referral network. He was drawing patients from dentists across 5 specific rural counties: Cayuga, Cortland, Seneca, Tompkins, and Ontario.
He had a real regional monopoly going, the go-to guy for oral surgery.
He really did. Then enter the defendant, Dr. Ingrasci. He's a young doctor, just finishing his training in oral surgery, wants to enter private practice, but doesn't know the area. So Karpinski hires him. And here is the crucial part of the agreement. Ingrasci signs a contract.
Promising what exactly?
Ingrasci promised never to practice dentistry and endo-oral surgery in those exact 5 counties, except in association with Karpinski.
Wow, never. And banning both the dentistry and oral surgery, that's aggressive.
Well,
So what happened? What was the breach?
Well, after the contract expired, they couldn't agree on a new partnership deal. So Ingrasci leaves. And 1 week later, just 7 days, he immediately opens his own oral surgery practice in Ithaca.
And Ithaca's in Tompkins County, right?
Yes, squarely inside one of those 5 forbidden counties.
And what was the impact on Karpinski's business?
It was devastating. Karpinski's practice in the Ithaca area dwindled to almost nothing. Ingrasci captured roughly 90% of the referrals that used to go to his old boss.
Okay, so a massive direct hit to the business.
Yeah.
What was the core legal issue the court had to resolve here?
There are 3 precise legal questions. Number 1, is a covenant illegal if it is unlimited in time, meaning it literally says forever? 2, is a covenant illegal if it is overly broad in scope, like banning dentistry generally when the employer only practices oral surgery?
And a third.
3, if it is overly broad, must the court void the whole contract, or can it enforce only the valid parts?
Got it. So what rule of law did the court apply? Please state the full black letter rule and break it down into its testable elements.
The black letter rule is this. Courts will enforce a covenant not to compete to the extent it is reasonable and necessary to protect the employer's legitimate interest.
Okay.
And this breaks down into 4 elements for our analysis. Element 1, geographic scope. Element 2, temporal scope, the time limit. Element 3, subject matter scope, the actual type of work prohibited. And element 4, severability, the power of the court to pare down unreasonable restraints.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, geographic scope?
The sub-rule here is that geography is reasonable if it matches the territory over which the employer's practice extends.
The actual footprint of the business.
Right. So in applying this to the facts, the court looked at where Karpinski's patients actually came from. His referral network was strictly those 5 small rural counties. Ingrasci opening up in Ithaca meant he was in direct competition for that exact same pool of patients.
So they weren't just guessing on the map.
Exactly. So the court's conclusion on this element was that the 5-county restriction was reasonable. It perfectly coincided with the area of influence.
Understood. Now, what about the second element, temporal scope, the time limit?
Yeah.
Because the contract literally said forever. That sounds crazy to me.
It does sound extreme, but the sub-rule here is that a covenant is not invalid merely because it has no time limit.
Really?
Yeah, it depends entirely on the circumstances. So in application, the court looked at when the breach happened. Ingrasci opened his competing office 1 week later. The competition was immediate.
Oh, I see.
Right? He didn't wait 10 years. He took the goodwill instantly. So the court's conclusion was that the lack of a time limit was actually reasonable under these specific circumstances because the breach and the injury were so direct and immediate.
Okay, that makes sense. If you steal the clients on day 7, the fact that the contract said forever doesn't really matter as much for the injunction. Now, let's get to the most controversial part. What about the third element, subject matter scope?
This is where Karpinski overreached. The sub-rule is that an employer cannot exclude a former employee from a profession where they are not in competition.
Okay, so how do they apply that?
Look at what Karpinski actually did. He practiced only oral surgery. But the contract banned Ingrasci from dentistry and/or oral surgery. Right. This would ban Ingrasci from general dentistry like filling cavities, cleaning teeth, things Karpinski doesn't even do. So the court's conclusion here was that this element was unreasonable and invalid because it was just too broad.
Because it's punishing the employee without actually protecting the employer's real business.
Exactly.
So if part of the contract is invalid, the general dentistry part, does the whole thing fail? Let's look at the fourth element, severability.
The sub-rule for severability is that courts have the power to sever impermissible parts and enforce the valid parts. This is divisibility or the blue pencil doctrine.
Literally editing the contract.
Yes. In application, the court saw that it could grammatically separate the words. The text said dentistry and and/or oral surgery, so they can just cross out dentistry and/or.
Leaving just oral surgery.
Right. So the conclusion on this final element was that the court decided to enforce the ban only on oral surgery, which allowed Ingrasci to practice general dentistry if he wanted to.
And after analyzing all the elements, what was the court's final conclusion?
The lower court's order was reversed. The holding was that the injunction is granted but modified. Ingrasci is barred from practicing oral surgery in the 5 counties. He is completely free to practice general dentistry there, or he can practice oral surgery anywhere else outside those 5 counties.
What about the money? because Karpinski lost a ton of business while this was being litigated.
The court also held that Karpinski is entitled to actual damages for the time Ingrasci was in breach before the injunction kicked in.
Wow. Okay, that is a surgically precise outcome from the court, but I really want to make sure the listener grasps that subject matter scope, rule the overbreadth issue. Can you give us a visceral hypothetical to make that stick?
Oh, absolutely. Let's call this the brain surgeon hypothetical.
I'm listening.
Imagine a world-famous brain surgeon hires a fresh resident. The employment contract says, when you leave, you cannot practice medicine in this city.
Okay, medicine is a huge umbrella.
Right. So the resident leaves, and maybe they're burned out on brain surgery. They decide to open a little walk-in clinic to treat common colds or, put Band-Aids on cuts.
Which is technically practicing medicine.
Yes. Under the text of the contract, they are in breach. But if we do the analysis, if a patient needs brain surgery, are they going to the walk-in clinic?
Definitely not. And if I have the sniffles, I'm not calling the neurosurgeon.
Exactly. They are not in competition. So the result here is the court would likely use that blue pencil, the severance doctrine, cross out the word medicine, and write in brain surgery.
Saving the contract, but narrowing it.
Exactly. Preventing the resident from doing brain surgery, but allowing them to be a general practitioner.
That perfectly illustrates it. Now, I want to pivot to one other detail in the case that's fascinating. There was a $40,000 promissory note involved in Karpinski, right?
There was, yes.
Because I think a lot of people assume you can just buy your way out. Can we do a hypothetical regarding this liquidated damages issue?
Yes. Let's call this the buyout myth.
The buyout myth, okay.
Imagine an employee reads their contract and it says, if you breach this non-compete, you owe $40,000. The employee calculates, well, if I steal these clients, I'll make $200,000 a year, so I'll just pay the 40 grand in cash and take the clients.
Like it's just a toll on a highway, a cost of doing business.
Exactly. But the correction here is that in Karpinski, the court said no. Unless the contract explicitly says the money is the only remedy, an alternative performance, the court treats that money as security against a breach, not a price tag for your freedom.
So they can take your money and shut you down.
Yes. The court can still issue the injunction stopping you from working and make you pay damages. You cannot just buy your way out of a non-compete breach.
That is a brutal wake-up call for anyone who thinks they can just cut a check and steal a client list.
It really is.
Okay, we've gone deep into the doctrine. Let's pull this all together for the listener, because they might be staring at an employment contract right now or prepping for a final exam. Can you synthesize this module into a non-compete diagnostic checklist?
I can. This is your step-by-step exam framework. If you see a non-compete issue, walk through these 5 steps.
Step 1.
Step 1, the consideration check. Was the covenant made in exchange for employment or experience? If yes, it passes. Proceed to step 2.
Okay. Step 2.
Step 2, the geography check. Does the restricted map actually match the employer's established client base? The red flag here is if the map is bigger than the client base. If it is, it's unreasonable.
Like claiming the whole state when you only work in one county.
Exactly. Step 3, the subject matter check. Does the restriction ban all professional activity or only competing activity?
With the brain surgeon rule.
Right. The red flag is if it bans non-competing work like general dentistry versus oral surgery, then it is too broad.
And if it is too broad, what do we do? Step 4.
Step 4, the severability check. If step 3 failed, can the court grammatically separate the bad terms from the good terms? If yes, you apply the blue pencil. You enforce the reasonable part and strike the rest.
And the final step.
Step 5, the remedy check. Is there a liquidated damages clause? Note that this does not automatically block an injunction. Look at the intent. Was it meant to be a price tag for freedom or security against breach?
It's usually security.
Almost always, so the injunction applies.
That is incredibly clear, a perfect 5-step checklist. So to wrap this up, if there's one massive takeaway from Karpinski for you listening, it's that while the law absolutely lets you protect your business, you cannot use a sledgehammer to crack a nut. You can stop a rival from stealing your patients, but you cannot destroy their livelihood unnecessarily just to feel safe.
That's the perfect way to phrase it. And I just add a final thought on that severance doctrine, the blue pencil. It really acts as a safety net for employers who overreach just a little bit.
How so?
Well, it saves contracts that would otherwise be entirely voided. As long as the employer wasn't acting fraudulently or in bad faith, the court will catch them, trim the excess, and enforce the court protection. It's a remarkably pragmatic area of the law.
It really is. It balances the scales. Well, thank you to the listener for joining us on this deep dive. Run your contracts through that checklist, and we will see you on the next one.